Mr. McGilkin.
Melanie, just before we took the break, I would have left off at my references to Morgan and Thomas.
That's right.
And essentially, the submission that we make is that on the issue of the application of the doctrine, quite correctly, as has been identified during the course of my learned friend's submission, I think it is correct to say that there is, in fact, no discretion in the application of the doctrine. And that's effectively the point that I was attempting to underscore with reference to the authority of Morgan and Thomas. And if I may, just to continue the submission, I wish to take board to Mills and Anderson, which was cited by my learned friend. And it's at electronic bundle page 488. And in particular, I wish to take the board to page 494 firstly. And in particular, at letter B of page 494. And if the board would permit me to read it. Yeah, certainly. So I lost the page for one moment, so I think I'm back now. Right. So this statement is supported by reference to Morgan and Thomas, and I'm satisfied that this decision does indeed support that statement, which appears to be taken almost verbatim from the judgment of Baron Park. And that's done by a party who afterwards becomes administrator to the prejudice of the estate is not made good by the subsequent administration. It is only in those cases where the act is for the benefit of the estate that the relation back exists, by virtue of which relation the administrator is enabled to recover against such persons as have interfered with the estate and therefore to prevent it from being prejudiced and despoiled. This simple submission that we wish to make as it relates to that aspect of the case of Mills and Anderson is that I do not think, and I could be wrong in that submission, but I do not think that Mills and Anderson was intending to lay down what could be construed as an exhaustive test, that the benefit of the estate could only be construed in circumstances where it is the injury to the estate which the potential administrator is attempting to avoid. I do not think that that's what Mills and Anderson, as a matter of principle, I think that it would be manifestly unfair if that is the construction to be preferred, simply because, as has been identified in the course of my learned friend's submissions this morning, there are a plethora of other issues or a plethora of other situations that can arise, essentially by which the administrator would be responsible for attempting to protect the estate and or preserve the estate. And it may not necessarily only relate to those circumstances in which an injury to the estate is being occurred, but necessarily to protect the estate and or for the benefit of the estate. So that's what we say respectfully as it relates to my learned friend's submission on Mills and Anderson. And I just wish to refer the board to one other paragraph before I go.
Before you do that, could I ask this question? As I understand it, as I understand the position, you say that relation back also validates proceedings. That is, these proceedings which have been commenced in this case. And if one looks, and the relation back test is whether the action was for the benefit of the estate. And so, therefore, if it's not for the benefit of the estate, the administrator, once appointed, can say, I'm not going to, the relation back doesn't affect any action that wasn't for the benefit of the estate. I was just thinking in terms of proceedings. In proceedings, there are many tactical decisions which are made by an individual. And some of those tactical decisions would be to make admissions or to call evidence or to take various acts. Would the administrator then, once appointed, be able to say, no, all those admissions, they weren't for the benefit of the estate, and I'm not going to rely upon them. I'm released from them.
Yes, I think, my Lord Stevens, I think that an administrator would be in a position to say that. Yeah. Because the test, which is identified in Mills and Anderson, in terms of that objective test, requires, firstly, an assessment objectively as to whether or not it was for the benefit of the estate, and two, assessing whether or not subjectively a decision may have been taken which really is not for the benefit of the estate at all. And that's in fact the paragraph that I was coming to refer the board to. So on the subjective assessment, it is open to the administrator, we would say respectfully, to say that that was not for the benefit of the estate. It could not have benefited the estate at all.
So the administrator, once appointed, could say the defense that was served, that wasn't for the benefit of the estate. I'm now going to serve another defense.
Or amend the defense accordingly.
Yeah. Okay.
Or procedurally may be entitled to amend the defense accordingly. So as to remove those particular aspects.
And how does the court know then what the issues are in the case? If the individual can then change it all subsequently as soon as he's appointed as an administrator?
But I mean, hypothetically speaking, my Lord Stevens, yes, that can occur. But amendments generally, as it relates to defenses and or statements of case, follow or allow pursuant to the civil proceeding rules. And there is a general test that has to be satisfied in terms of whether or not the amendment could be allowed and or permitted. So in those circumstances, the most that I can say, I can't put it any higher than that, the most that I can say is that the administrator at that point in time will have to satisfy the requirements in terms of the civil proceeding rules to be able to amend their pleadings. I can't put it any higher than that. As much as I would like to assist my Lord Stephens in terms of the hypothetical situation, that's as far as I can go. So I hope that I've been of some assistance, at least as it relates to the question of my Lord Stephens.
Thank you.
So the paragraph that I was just about to take the board to is in fact at page 494 and from letters G to H. Right, so at the bottom of the page at paragraph H, and if the board will permit me to read, I have, however, to consider whether an act done for the benefit of the estate means objectively an act which, looking back, is of benefit to the estate, or whether it may include acts which were done subjectively for the benefit of the estate, even though, looking back, they have not benefited the estate at all. it is perfectly clear that in arriving at his decision to conclude an agreement with Mr. Dodson, Mr. Peacock believed that he was acting for the benefit of the estate. So that the point that we simply wish to make, as it relates to this particular part of the case of Milton Anderson, is that the objective test, as has been set out, is an objective test that requires an assessment firstly as to whether or not the actions which were performed were for the benefit of the estate. That's objectively, has nothing to do with any discretion as to, or any looking at the actions as it relates or the intention of the intended administrator. But if, however, subjectively, when we assess the actions, it appears as if it was not for the benefit of the estate at all, then in those circumstances, I believe that the doctrine would not apply. But what we say respectfully is that that subjective test is not applicable in this particular case. What we say is that when the objective test is applied, the actions of the respondent were in fact for the benefit of the estate. Now, Mills was followed by Appellant and LD Law Limited, which is at the electronic bundle at page 497. And that is in fact a decision of Wynne Williams on appeal from the decision of Judge Rydell in the Chelmsford County Court. That case concerned, of course, whether or not the claimant who had not received a grant of letters could initiate a claim against the defendants, the solicitors of the deceased's former wife, for wrongful interference on their failure to deliver certain papers to assist him in applying for the grant of letters of administration. And I wish in particular to take the board to page 504 of the electronic bundle. And in particular, paragraph 32, which is at letter E. And if the board would permit me to read, Wynne Williams, Justice Wynne Williams is saying, in Sharon O'Neill, the law and practice of intestate succession, third edition.
Now, we've lost the sound.
No authority is provided for that proposition, but
I'm so sorry.
seems to me it would be an extraordinary state of affairs if that were not so. If the trespasser is in the example set out at paragraph 24 above, was not merely refusing to release the property to deed, but what was in the process of destroying the deceased's property, it would appear extremely strange if nothing could be done immediately to prevent it. And he continues at paragraph 33. It appears to me that Mrs. Mahoney is forced to adopt this stance, since otherwise she would be forced to accept that there are some circumstances in which the person who has not been granted letters of administration, but who is entitled to a grant, can not only take possession of the property of the deceased, but also sue to prevent its destruction or disposal. I do not accept that paragraph 34, that the law confers the right to take immediate possession of property upon an individual, but nonetheless says that such a right cannot be enforced by legal action in the courts of England and Wales. I can think of no principle or practical reason why that should be so. And in the absence of clear authority, I would not be prepared to accept the law as such. Now, I believe it was my Lord Burroughs, I believe it may have been, and I may be incorrect, indicated when I referred to Cuddle and Law earlier before the break, that the case of Ingle was not cited in the case. But there is, in fact, which is the paragraph that I'm going to come to, a reference to a similar authority, similar in terms of the decision in Ingle, which in fact was considered. And that is at paragraph 35, at the top of page 505 of the electronic bundle. And if the board would permit me simply to read, it does not seem that the decided cases in the bundle of authorities touch upon this particular point. Bola, which he refers to here, is authority for the proposition that if a claimant brings an action in a representative capacity as administrator, then that action is a nullity if he was not at the date the action was commenced an administrator with a proper grant. So that's similar in terms of the decision in Ingle. It is not authority for the proposition that a person who is entitled to a grant of letters of administration, but who has not obtained such a grant, cannot maintain an action for wrongful interference with property if, as a matter of law, he is entitled to immediate possession of the property in question. And then he concludes by saying that Mills and Anderson is not helpful in terms of the particular point. So that what we respectfully say is that this authority is clear as it relates to providing exceptions where the principle of relating back would apply not only to the actions of the respondent in terms of renewing the lease, but also as it relates to the initiation of proceedings. Now, my learned friend for the appellant, then took the board to three authorities, Long and Burgess, Smith and Mather, and Arthur and Holmes. And if the board would permit me, just simply to make the point that those particular authorities are distinguishable, especially as it relates to the facts of this particular case. And firstly, I would deal with Long and Burgess. Even from, and it's at page 507 of the electronic bundle. And even from a cursory reading of the headnotes, it is clear that on the facts of Long and Burgess, what occurred is that a notice to quit was issued by the landlord prior to the defendants of the claimant, obtaining letters of administration. And it was only after they had obtained letters of administration did they attempt to initiate a claim to say that the principle of relating back should apply, and therefore the tenancy must have continued to vest. Ignoring, of course, I think in terms of that submission, ignoring, of course, that there was in fact a notice to quit, which would have determined the tenancy prior to obtaining the grant of letters of administration. So that what we say respectfully in terms of distinguishing Long and Burgess initially is that on the facts of Long and Burgess, the facts of Long and Burgess are not on all fours with the facts of this particular case. It is only applicable, that is Long and Burgess, it's only applicable if it is that the board accepts that the respondent on the 11th of January, on the 12th of January 2011, when she caused the notice to be served, that notice was not properly served, and or that action did not relate back when she obtained the grant in November of 2012. That's the only applicability of Long and Burgess. It doesn't apply because Long and Burgess is only helpful if it is that we are construing that the notice to renew is not valid, and therefore the tenancy would have terminated on the 31st of May 2011, and that therefore the principle of relating back can't assist in terms of reviving it. So and what we say respectfully is that on the facts of this particular case, that's not the case. Because the respondent's actions on the 12th of January in causing that notice to be served, we say respectfully, would have, of course, extended and or renewed the tenancy for another 30 years, properly so, and that on obtaining the grant of letters of administration in November, that it would have, of course, related back to that action which was performed in November.
But isn't the principle that you get from Long and Burgess that where property rights are concerned, you need to have certainty, and where a notice is served, be it a notice to quit or a notice to extend a tenancy or anything else which will affect or create new rights in property, you have to be able in principle to tell at the time when the notice is served whether it's valid or not. You can't have a system in which you just wait to find out if it's valid, depending on events that happen in the future and depending on choices that may be made in the future. There either must be a tenancy subsisting from the date when the notice is served or not. It can't.
And what we say respectfully is that on the facts of this case, when the notice was served, the tenancy was still subsisting. It was served in January.
Yes, but was the notice valid when it was served or not? Did it renew? Did it have the effect on that day of renewing the tenancy for another 30 years at the time when the notice was served?
Yeah, and that's what we say respectfully, that it did.
It did. So on that day, it went immediately and was immediately effective, irrespective of whether your client did or did not in the future become appointed as administrator.
Okay, so that what we say respectfully, if the question is put in that particular way, is that we say that the notice is valid because of the fact that the respondent was appointed as administrator in November of 2012.
So what if she hadn't been? What if she'd decided subsequently that she didn't want to become administrator, or that she had become administrator but decided that she didn't wish to extend the lease? What would happen then? Then it
would have expired.
Then it would. So until the position's been sorted out, there's neither a tenancy nor no tenancy. You just don't know. Whether there is or not is going to depend on what happens in future.
If it's put in that particular way, it appears as if that's sort of the conundrum which it throws up. But what we say respectfully is that once the notice is served, that is a notice to renew, once that notice is served, the effect of it, of course, is that the intention is pursuant to the legislation to renew the tenancy when the tenancy expires. In other words, from the 31st of May 2011. So that the notice, when it's served, it's simply an intention to extend the tenancy from the 31st of May, as opposed to from the date that the notice was issued. The date upon which the notice was issued was simply a marker point, because prior to the amendment to the legislation in 10 of 2020, any notice to renew had to have been served before the period of 6 months, before the period 6 months prior to when the tenancy would have ended, which would have been 6 months prior to the 31st of May 2011. So that what we say respectfully is that when the notice was served, since the tenancy, as a matter of fact, was still subsisting, that any subsequent grant of letters of administration, which may or may not have, which may have occurred even prior to the tenancy expiring, would of course solve that hypothetical situation. Having obtained the grant of letters of administration after May of 2011, we say that that's the reason for the applicability of the doctrine. And while we accept that Long and Burgess is principled for the fact that there should be some certainty as it relates to rights, and especially when it relates to property rights, respectfully, we say that the legislation in this particular case is somewhat unique in the sense that it was intended to protect tenants who, of course, had invested over a particular period of time a significant amount of their resources into the landlord's property, and therefore would be robbed of that opportunity when landlords unfortunately simply determined tenancies before the time period was up. So
well, I see that, but what about after the period is up? June, July, August? Suppose no letters of administration are taken out for the next few years. The landlord doesn't know whether there's a tenant that's going to turn out to have been a tenant who owed him rent, and which meant that he couldn't re-let the land or re-enter it or do anything with it, or whether if no letters of administration are ever taken out, it turns out to have been not validly extended, and therefore it was his property all the time. But that's an intolerable situation, isn't it, to use the words of Lord Justice Asquith?
Yeah, I would say that in that particular circumstance, I think that I must concede in that particular circumstance, it would be intolerable. But what we say respectfully is that in a situation in which no letters of administration are taken out, then of course the tenancy is determined. Right? In other words, the landlord cannot wait inevitably, but that's very different from a situation in which the notice is served before the expiration of the tenancy. So that where the notice is served before the expiration of the tenancy, the landlord has at that particular point in time a notice. If it turns out that the notice is not valid, then of course the tenancy is determined. But it may very well be that the notice is in fact valid. And what we say respectfully is that assists in terms of understanding and interpreting the landlord's rights and or obligations. But it is particular in the context of this particular piece of legislation, which is the point that we're making, in that the legislation was intended to protect tenants.
But it wasn't intended to give tenants or their successors an option, as it were, to wait and see whether they decide that they would like to have extended the lease or not. It wasn't intended to go that far.
No, it was not.
But that's the effect, isn't it, of your submission? Because what your client could do is serve the notice before the expiry of the lease, and then make a decision subsequently whether to adopt that by becoming the administrator or not to do so, just to let it languish.
But I think that in this particular case, the intention of the respondent was made very clear, that it was in fact the intention to apply for letters of administration. And in fact, the letters which were written by the respondent, even prior to the notice being served and even after the notice was served, clearly indicated her intention to apply. So that what we say on the facts of this particular case is that it doesn't put us into that sort of conundrum whereby the landlord is waiting, wondering whether or not the person from whom I've received this notice intends to apply for letters of administration. Here you have clearly, and the respondent is someone who, of course, must have either been known to either the appellant and to his siblings, because they have been long-standing persons on the property, etc. But the point that I'm making is that there was a clear intention from the correspondence that the respondent in this particular case had intended to apply for letters of administration, so that the landlord would not have been waiting, wondering whether or not the intention was, or that this notice would have been valid, and wondering whether or not, in fact, the person from whom I've received the notice intends to apply for letters of administration. So that's what we say respectfully on the facts of this particular case. It's slightly different because there was a clear intention. The notice is signed by the respondent as an intended legal personal representative, which was an issue that was raised by their lordships in the Court of Appeal when they were looking at whether or not the notice had been validly served, or whether or not the notice had been properly served as part of the transcript in the Court of Appeal. And it was clear that the intention was, at all points in time, even when the notice was served and even prior to the notice being served, that the respondent intended to apply for letters of administration. So there was no question here. The landlord here was not left in the dark and wondering what was going to happen when this notice was served.
Could I ask two questions? First is, the letters of administration can be applied for. There's no time limit. You can apply for them decades later. Is that right?
Yes, that is correct.
So the period of indecision could continue for decades. I appreciate that you distinguish this case but looking at it as a general principle, the area of the period of indecision could last for decades.
For indecision, only if we think about the fact that there is no clear intention by someone to apply for letters of administration.
Well, tell me, then how does the landlord know that the other siblings aren't also intending to apply for letters of administration? They're entitled, aren't they, to apply for letters of administration?
Yes, they are.
Yeah. Well, how does the landlord know that your client might wish to do so, but somebody else might wish also to do so?
Of course, the short answer to the question is that he does not. But on the facts of this particular case, we do know that the landlord was approached by all of the persons who were entitled to apply and had indicated to him their intention. So that having received the notice subsequently from the respondent, what we say respectfully is that the landlord would not have been in an ambivalent position and wondering whether or not other persons were going to apply. Because as I took the board to the particular part of the respondent's witness statement before the break, there was a clear intention on the part of all of the beneficiaries, or at least the siblings of the respondent, and in addition to the respondent, a clear indication by them of their intention to deal with the estate together, and not that there was going to be some sort of separate sort of application from those persons who were entitled to benefit from the estate.
Upon what date did the respondent apply for letters of administration?
4th of May. The 4th of May, 2012.
Thank you.
So it was a question which was asked by their lordships in the Court of Appeal as part of the transcript, but we did not have the precise date at the point in time.
Yeah, thank you.
It is the 4th of May 2012. So that my friends are correct when they say that looking at the estate number gives an indication in terms of the year that it was applied for. So that the estate number being 2012 would give a clear indication. But that does not mean that we have not signaled, even though that's when the application itself was filed. That does not mean that having regard to the letters which form part of the electronic bundle and which are attached to the witness statement of the respondent, starting, of course, at page 133 of that electronic bundle, it didn't demonstrate a clear intention to apply for letters of administration.
During the period of uncertainty that my lords have referred to, is there any power of the landlord, assuming that there is a renewed tenancy in place, to terminate the tenancy for breach of its terms? I mean, this is presumably it's a statutory tenancy, but it must be subject to some kind of right on the part of the landlord to terminate for failure to comply with the tenancy conditions, is it?
Absolutely. Yes, certainly.
Could you point us to where that is in the 1981 Act, perhaps?
Well, it would be general landlord and tenant law if the rent wasn't paid.
But yes, 7. It's...
Yeah, if the rent is not paid.
So the landlord has the rights, albeit perhaps more limited than under a commercial arrangement, to
Yes.
The landlord would have to know that it was a tenancy with that particular individual.
Yes, certainly. So it's paragraph 7, section 7, page 405 of the electronic bundle.
Sorry, what page was that?
405.
405
of the electronic bundle.
I've only got the first 2 lines of that.
Yes.
And then it goes over to, in terms of my copy, it continues, oh no, yes, it continues over page 407.
No, that's a different act. That's the Wills and Probate Act.
Oh no, that's, yes, so the entirety of it is not reproduced. But section 7 deals with the landlord. If you just look at the marginal note, the landlord's redress for non-payment of rent.
Well, what does it say? Can you read it out to us?
If my lord would just permit me just one moment to pull up the.
Well, I think it's actually 5.4 on page 403, if the rent is in arrears.
Ah.
Yes, so that is correct, my lady. This would be a page 403.
So the Land Commission then gets involved.
The Land Commission can. So in cases where the chattel house is erected, the Land Commission may make an order for termination of the statutory lease, tenant eviction from the land, and for removal of the chattel house from the land by the tenant. That's subsection B.
Can we just pursue the property point for a moment? If the option is exercised, the estate of the tenant, in our case, will get rights in respect of the land as a result of the exercise of the lease. That's correct, isn't it? And they are encumbrances on the land. So the landlord has land which is encumbered by the renewed lease.
Absolutely. Yes.
So for how many years would for the purposes of limitation, how many years would have to pass for that right to be extinguished?
So if I understand my lady's question, is the right in relation to the determination of the statutory tenancy?
No, it's the right, as a result of exercising the option, there is a right to an extended lease, extended tenancy. So
yes, 30 years.
The land is encumbered not just with the prior tenancy, but with the new tenancy as well.
Yes.
And the landlord is therefore in possession of land, in the ownership of land, which is encumbered. How long does it take for that interest to be prescribed if nothing happens on the land?
In answer to my lady's question, if I understand my lady's question, the tenancy itself would be extended for another 30 years.
Yes.
Once it's renewed.
Indeed.
So that would be, if nothing happens,
yes.
as it relates to the land, if nothing happens at all, then I think that the tenancy is determined at the end of the first 30 years, and I don't think, as my learned friend indicated, that the issue of prescription arises.
Okay, but if the option is exercised and it's a valid notice, because your case is it's a valid notice, isn't it automatically extended for the 60-year period?
For 30 years?
Yes, 30 years on top of the existing 30.
Yes.
So that the land will be encumbered for 30 years from the date of expiry of the first tenancy.
Yes, from the 31st of May 2011. It will be encumbered for another 30 years.
This situation is possibly unlike those in the cases that we have seen, because there is a subsisting property right independent of any action in the courts. So it would be very odd, perhaps, if the administrator subsequently appointed, but appointed during the period of the extended tenancy, could not take action to enforce that tenancy.
Certainly, I agree with the proposition by my lady.
So the administrator could start a new action now?
Yes, the administrator could start a new action. During the break, and even in terms of my preparation, from my review of our Limitation of Certain Actions Act, it does not appear as if there is any limitation on the administrator.
Is there any reason why she shouldn't? Well, they shouldn't, sorry.
Yes, yes, please, my lady.
I mean, they would be liable for the full period of the rent, of course. It's because they would be claiming the tenancy. They couldn't take the benefit and not the burden.
Yes, certainly. The issue of rent, of course, they would be liable for the issue of rent for that particular period of time.
So
I hope that I provided assistance to my lady, since I had to attempt to reformulate the propositions that were being put.
Indeed, and I'm perfectly happy with your reformulation. So if the Court of Appeal had decided this case against the administrators could simply have started a new action.
Could have simply started a new action. Her being armed with the grant of letters of administration could have simply started a new action. And of course, that would have been simply for a declaration, if it were, that of course the statutory tenancy was renewed as it relates to the principle of the application,
Right.
so to speak, of the doctrine of relating back.
Yes. So they don't have to show they were in occupation as such, physical occupation.
No, because what we say respectfully, and that's the reason why I took the board to the decision of their lordships in the Court of Appeal in the Carl Hector case, because of course it's an interest which runs with the land. That's the intention that's being created. But they also do not have to show that they're in physical occupation.
So
In order.
irrespective of the fact pattern in Ingle and Moran, where the administrator seeks to rely on the commencement of proceedings when there wasn't letters of administration, the landlord is at all times at risk during the course of this tenancy that there will be an administrator who takes proceedings to enforce the terms of the tenancy. It's not just a risk which arises because proceedings have been taken at a point in time when the administrators did not have a grant of letters of administration. It subsists for the entire period of the tenancy.
Yes, that's what we say respectfully.
Yep. So that the point made by Asquith is not really, Lord Justice Asquith, was not really applicable in the circumstances of this case.
Of this particular case, yes, yes, please, my lady.
Sure.
I was at the point in terms of distinguishing the authorities of
Yes.
Long and Burgess, Smith and Mather, and Arthur and Gomes. And I think that in terms of the discussion that has occurred between bench and bar, that I think that we have somewhat moved past that particular issue, so that I simply wish to circle back to it, simply to indicate that the same position that we advance as it relates to Long and Burgess, and the fact that it is distinguishable on the facts of the case, equally apply to my learned friend's submissions on Smith and Mather and Arthur and Gomes, both of which, of course, but Smith and Mather similarly, factually, to Long and Burgess, and Arthur and Gomes involving an issue as it related to an executor as opposed to an administrator. So that's the simple point that we wish to make as it relates to my learned friend's submissions and his reliance upon those particular line of authorities. So just to conclude this point, unless there are any further questions that I hope that I can assist the board with.
No, I'm looking at my
Yes, you can assist me with this. The other part of the reasoning in Long and Burgess is that by the time the administrator, the estate became vested in the administrator, the right in question had been extinguished. Why? How does it operate? How do you say it operates in this case? Because in order to serve a valid notice of extension of the lease, you have to be a tenant within the meaning of the Act, do you not? Which means somebody entitled to possession of the property. At the time when your client serves the notice, she is not a tenant, as we know. She wasn't entitled to possession of the property. When she becomes the administrator, how does the lease devolve upon her, given that it's come to an end in the meantime?
But I think that takes us back to the argument or at least the submission that I was making, to suggest that the service of the notice didn't extinguish the lease. If it
didn't. I'm not suggesting it did. I'm just saying at the time the notice was served, she was not entitled to possession of the property. She wasn't a tenant. The lease then comes to an end, and she then has vested in her the estate. How can it be said, as a matter of law of administration, that that estate vested in her includes a tenancy?
And I think that's a submission that we make in terms of the applicability of the doctrine. I think that I accept that on the facts of this particular case, that the respondent, when she served the notice, did not have a grant of letters of administration. So I think that's common between my friend and I think that and we accept that.
Yes.
I don't fully accept respectfully that she was not entitled to possession. I accept the fact that she may not have been construed on the literal interpretation as a tenant within the meaning of the Act, but certainly as a beneficiary. And the fact that the tenancy vests in the estate for successors entitled, that she was in fact entitled together with her siblings, that she was entitled to enter into possession.
Oh, so you're submitting that she was a tenant within the meaning of the Act, are you? Within the definition of a tenant in the Act?
No, I'm not submitting that she was within the definition of tenant. What I'm submitting is essentially that as a beneficiary of the estate, because she was in fact a successor entitled, together with her siblings to the estate of her mother, that she was entitled to enter into possession during the currency of the tenancy. She was not closed at the point in time that she issued the notice because she had not obtained the grant of letters of administration, so that she cannot be construed within the literal interpretation of a tenant, that she was in fact a tenant. So that this simple point that I'm making, and I hope that I haven't detracted from the point that I was really attempting to make, is that essentially the service of the notice, I mean, it seems like a circular argument, but the service of the notice, we say respectfully, of course, renewed the tenancy. It didn't bring it to an end.
Well, how is that the case, though? I didn't understand that, because Section 6 says that the option for a renewal is an option that may be exercised by the tenant. So unless your client comes within the definition of being a tenant, it doesn't renew the tenancy when it's served.
And what we say respectfully is that she comes within the definition of the tenant on an application of the doctrine. That's as high as I can put my case. And that's the case that we argued, and the case that we have always argued. That's as high as I can put my case. The doctrine and its applicability in terms of relating back to the action that when she engaged in the service of the notice, of course, would have clothed her at that particular point in time, the application of the doctrine with the necessary legal requirement and or legal armor, as it were, to serve the particular notice. And the effect of it was the renewal of the tenancy. it's as high as I can put my case. It's the way that we have always argued the case and the way that the Court of Appeal has looked at the application of the doctrine.
But is what you're saying is there's a different line of authority dealing with the steps that the administrator can take to safeguard property before the grant of letters from the line of authority which deals with actions in the sense of proceedings before the court. Even if it's correct, even if Ingalls and Moran is correct, I thought your point was it didn't affect the other authorities like Morgan and Thomas and the other cases cited in Williams, that there can be action taken by the administrator short of legal proceedings, which is validated by the doctrine of relation back because it's beneficial to the estate on the particular facts of the case. So that there were...
My lady has put it better than I did.
No, it's one way of putting it, and yes, I thought you were putting it that way. If you were wrong on Ingle Moran, still doesn't cover, as I understood your answers to me, the taking of the notice, the making of the notice, giving of notice, because that is covered by different authorities.
Yes.
I thought, you also took us before to Hector and Keith, which seems to make it clear that the tenancy rights, including the right to exercise the option to renew, form part of the estate. And if they form part of the estate, then they must be capable of being exercised, even though there's no sort of physical human being for a while who can go into possession. Otherwise, one's in a slightly odd situation that if a tenant dies before the lease expires and before having, well, even after having given notice to renew, there's nobody for a period who has that immediate right of occupation, and that can't be correct.
Right, and that's the point that I think I was attempting to make in answer to my Lord Legate's question. Yeah.
It's also my point about sorry. I was saying it was the same point as the encumbrance point in many ways, that once, if the notice is valid and has extended the tenancy, there's an encumbrance on the land.
Yes, yes. So
I'm afraid I haven't understood that argument. There always is someone in whom the tenancy is vested for as long as it subsists, until the administrator is appointed. As I understand it, there's a public official who's who owns the rights, has the rights.
Yes, it will be vested in the Administrator General.
Yeah.
Yes, but he's the administrator, not the owner of the right.
Not precisely.
No.
No, the right is vested in the estate at all times, as I understand it, unless it becomes what we call bona vacantia
You can serve notice on the Administrator General, and the Administrator General could serve notice himself.
Yes.
And he could be asked to do so. And just on a slightly different point, I asked about whether or not the landlord, the appellant, accepts that subsequent proceedings can now be commenced without any limitation defense being available. So the interesting question is whether a landlord can run a title against his tenant wouldn't arise if that was removed from this case. The landlord went into occupation, the appellant went into occupation in 2012. And if the limitation period is 12 years, the proceedings could be issued tomorrow.
Yes, so that was the short point that we were making in answer to that particular question.
But I don't think the limitation period is 30 years plus 12. I don't think you have to wait until the end of the tenancy.
I'm not sure if I'm following my lord's observation.
I was just concerned that if the proceedings are a nullity, to make sure that we are absolutely clear in this case that the tenant, that your client would be able to commence proceedings again without facing a limitation defense.
Yes, and as far as we are aware, in terms of the research that we have done, albeit very brief research, when the question was asked, we have not come across, as it relates to the Limitation of Certain Actions Act, a section of the Act, and I'm subject to be corrected, but we haven't come across it, a section of the Act that would limit the respondent from initiating an action. So just to conclude the point as it relates to the issue of the application of the doctrine, it's just simply to indicate, based on the authorities that we have cited, both in our written argument and in terms of the oral submissions to the board today, that respectfully, as it relates to the application of the doctrine, that there is no time lapse as it relates to the application of the doctrine. There is no discretion as it relates to the application of the doctrine, which requires some assessment of the intention of the intended administrator in terms of their actions to preserve and or protect the estate, and that the doctrine applies objectively, as it were, to actions which are done for the benefit of the estate, objectively identified. And in this particular case, we say respectfully that an objective assessment, that it means that the doctrine is applicable because the actions of the respondent were in fact for the benefit of the estate. The tenancy having been vested in the estate and subject, of course, to being extinguished, as it were, and therefore lost all entirely to the estate, that the actions of the respondent, respectfully we say, were in fact for the benefit of the estate, and that the doctrine applies on the facts of this particular case. The other issue, unless I can assist the board further as it relates to that particular issue.
Could I just ask, I think it's being put to you that the position that you are advocating will create a great deal of uncertainty for landlords. They would not be able to work out what the position of the tenancy actually is, and you may end up with many years' delay before the appointment of an administrator. Is the practical answer to that if the landlord is not paid the rent that is due, the landlord would just immediately be able to terminate the lease, so that any uncertainty is in fact theoretical and not practical?
Yes, Redress. The short answer to the question would be yes. Practically speaking, that the landlord has some form of redress, as it were.
Thank you.
So yes, so that's the short answer to the question. So the only other issue, which I don't mean to be very long in terms of my oral arguments on, would be the issue of locus, as my friend has broadly indicated, and that is as it related to the applicability of Section 39 of the Supreme Court of Judicature Act, and whether or not their lordships in the Court of Appeal correctly exercised their discretion pursuant to Section 39. And what we say respectfully is that their discretion was accurately exercised and properly exercised. And we say so for the reasons that we've set out in our written case, and I don't mean to trouble the board as it related to those particular aspects, save to say that my learned friend for the appellant makes some takes some issue with what he describes as an ambushing of the counsel for the appellant in the Court of Appeal on the issue of relating back. And what we say respectfully is that there was no ambushing. That's our respectful position. Firstly, because the written arguments which were filed by the appellant attached as well their written arguments in the court below, which also dealt with the issue of relating back. The extracts from the transcript of the hearing in the Court of Appeal, I think, accurately demonstrates that counsel for the appellant understood the applicability of the doctrine, even though my learned friend for the appellant before the board says that it's somewhat a difficult doctrine to grapple with and to contend with. But he understood the applicability of the doctrine, so much so that he was even prepared, as he did, and conceded the applicability of the doctrine on the facts of this particular case.
But it wasn't an issue when counsel turned up for the hearing, was it? Relation back. I mean, it's about the worst form of ambushing you can get as counsel, isn't it? When you come in and then the court asks you to deal with a point that you haven't prepared, you haven't had time to get out the authorities, even if you argued it at first instance. You need to have some notice that you've got to deal with it. Or is that not how you expect to deal with things in Trinidad?
That's precisely how we deal with things in Trinidad. In fact, right. There are appeals, procedural appeals, which were argued without written arguments before an amendment to the civil proceeding rules that required written arguments to be filed by a particular time, so that the notice of a procedural appeal would be filed, and when you show up on the morning to argue that procedural appeal, there are a number of issues that arise on the facts of that particular case that would be taken by their lordships in the Court of Appeal. But no issue was taken by counsel for the appellant that he required an adjournment or that he didn't appreciate and or didn't understand the position, because it was all argued before the trial judge below. All of the issues as it relates to the issues of relating back and its applicability. And in fact, as part of the submissions for the appellant, their written argument in the Court of Appeal, they agreed with the trial judge's finding that the issue of relating back did not apply. That's part of their written argument, their skeletal arguments in support of their notice of appeal. So the point is that having demonstrated by way of your written arguments, both in terms of attaching your submissions below and in terms of the position that you took on your written arguments in the Court of Appeal, that you understood the doctrine and understood its applicability, I don't think that the appellant is on firm ground to say that I was ambushed or that I was not properly prepared to address the issue of relating back. And that's the point that we say, that's the point that we make respectfully.
So if you put something into your skeleton argument or into a skeleton argument which you annex to your skeleton argument, you must be ready to argue it.
You must be ready to deal with it. Yep. And unfortunately, it does happen to all of us as counsel, whereby there is a point which has been, or a question which has been asked that we may not be fully prepared to deal with. And as counsel, we know how to respond in those particular circumstances. Either we concede that we are not prepared to deal with the point, or if we are prepared to deal with the point, we proceed with the point. And the former of those two positions that I just advanced was not advanced by the appellant. But clearly from, and I just wish to commend the particular parts of the transcript to the board. They can be found at the page 278. line 34 to 44, at page 280, which would be internal page 13, lines 4 to 19.
As my Lady Arden says, we're here now. But,
Yes,
but putting it at its mildest, it might have been appropriate just to give it a little bit more thought and to give everyone an opportunity to consider the matter. There are difficult issues that arise in this case, and but we are where we are.
yes, certainly. So that's the point that we wanted to make in response to what my friend has said on the issue of the applicability and the way that their lordships in the Court of Appeal approached the applicability of Section 39. The only other, well, there are two other points, very briefly, that I wish to take before ending our submissions. And that's on the issue of the nullity point that my learned friend has raised. And I think that we have attempted to address that by reference to the exceptions to the applicability of the doctrine to proceedings, and in fact, in my reference to the extracts from Cuddle and Door, and as well from the extracts of the Mortimer. So I think that we have attempted to address that particular issue, and as well as we know that potentially it may very well be that there is no issue that can arise as it relates to the respondent instituting new proceedings. The proceedings which were instituted, these present proceedings, contain the element of trespass as well, which was found by the learned judge, and that element of trespass would have occurred during the subsistence of the lease. So that issue arises as well, and the fact that that aspect of the respondent's case cannot be determined as a nullity, having regard to the fact that my learned friend did accept that as it relates to trespass, and trespass which occurs during the subsistence of the lease, that even before you're appointed as an administrator, that you may be entitled to introduce, to bring proceedings.
Just to clarify, when you say trespass occurred during the existence of the lease, do you mean prior to the 31st of May 2011?
Prior to the indisputable lease. 31st of May 2011, because it's an accepted fact in terms of the admission by the appellant during the course of the trial that he did enter upon the property in or around March of 2011. So this would have been prior to, and did engage in some clearing of the land.
Was he found to have trespassed after the 31st of May?
Well, there is an element of trespass after the 31st of May.
Were damages awarded for that?
I beg your pardon, my lord?
Was an award of damages made by the judge for that?
The award of damages, and I want to be fair to the learned judge, and if my lord would just permit me to get the reference to the learned judge's decision on that particular issue in the electronic bundle.
Yes, thank you.
So it starts at page 222 of the electronic bundle. The issue of the issue of trespass is dealt with beginning at page 233 under the rubric the fourth issue, and concluding on page 234. So the learned judge says at paragraph 46, that the defendant is not denied that he is in occupation of the premises. However, the defendant testified he began occupying the premises in January of 2012 and not since January of 2011 as contended by the claimant. And then he goes on at paragraph 48. With respect to the claim, the claimant is testified in April of 2011 in relation to one of the neighbors contacting her about persons on the property who were cutting down trees, and that the claimant had removed those trees in December of 2011.
But then he goes on to question that evidence, doesn't he? I'm not quite sure what he...
Yeah. At paragraph 50, yes, he begins, neither witness gave evidence as it relates. But there is no such proof. In fact, the testimony of the defendant in cross-examination is that he was personally present
I see.
when the bush was cut. He was not asked about the trees by counsel in cross-examination, so that the evidence remains wanting in that regard. The court is of the view that the defendant has committed a trespass onto the premises. By entering premises, he had no lawful authority to enter.
So that you say was a finding of trespass before before January 2012, is that right? In April 2011.
In April of 2011, it contains, yes, the issue as it which the learned judge seems to have accepted as an admitted fact,
right,
by the appellant, that he was on the premises prior to the extinguishing of the lease in May of 2011.
Okay.
Yeah, 2012.
Yes, so, but they don't have no higher than that. So that the last issue that we wish to address, which we have set out in our written submissions, would simply be the issue of leave, and only to make the point, as we have set out in our written submissions, that when their lordships in the Court of Appeal came to the conclusion that there was no genuinely disputable issue, they came so to the conclusion on the basis that the counsel for the appellant had admitted that there was no genuinely disputable issue in the sense that the applicability of the doctrine of relating back applied, and that their lordships in the Court of Appeal would have been applying, and I just simply wish to commend this particular authority to the board, would have been applying the decision in the Attorney General of Trinidad and Tobago and Lennox Phillip, which forms part of which is part of the supplemental, which is a supplemental authority which has been provided to the board. The reference in the electronic bundle is in fact to the substantive decision and not to the decision on leave, so that the supplemental authority which is provided refers to the decision on the issue of leave. And just simply to commend paragraph 23 of the judgment of Mr. Justice of Appeal Mendonça in that particular case, where he, of course, would have concluded that the fact that the appellants were unable, essentially, or admitted, in fact, the applicability of the law as it related to the facts of that particular case, that it demonstrated that there was no genuinely disputable issue. So that is in the application of that particular case that their lordships in the Court of Appeal on the issue of leave would have been led to make the decision that they did as to whether or not there was in fact a genuinely disputable issue. Since even for cases or appeals which are as of right, the board has said that the issue of a genuinely disputable issue also has to be determined even on appeals as of right. And that's the only submission that we wish to make orally as it relates to that particular issue on the granting of leave. And unless I can assist further, those are the submissions of the respondent.
There appears to be no more questions. I should actually just draw your attention and that of Mr. Burial to the fact that the notes in Sonnets refers to a decision to which I was party 20 years ago called Hak vis Singh. You probably did look at it, but it's not on precisely the point, but I do refer to the recommendations of the Law Reform Commission, which suggested that the effect of Ingle and Moran on an administratrix who wanted to, on a widow who wished to take proceedings for personal injury suffered on the death of their husband should be changed. And I also cited Lord Justice Singleton, who said that Ingle and Moran was on a blot on the administration of the law. I simply draw that to your attention. It doesn't directly deal with this point because it deals with the civil procedure rules in the United Kingdom, in England and Wales. The reference is 2001, 1 Weekly Law Reports 1594, 1 Weekly Law Reports 1594, or 2001 EWCA, Civ, CIV 957, which is what we call the neutral citation, which is available on the network. Yes, thank you. Thank you very much.
Milady, can I deal with the trespass point first? As we understand page 234, and we have looked back at this, the position the judge appears to have adopted is where the appellant had definitively entered the property in January 2012. The judge took the view that entitled the claimant to a nominal sum, and he ordered $3,000. He does not say anywhere in his judgment that he's assigning that figure for any trespass prior to the 31st of May. But he does acknowledge that there was an admission that the defendant was present when bush was cut. The only observation I'd make in relation to that is that could not be to the detriment of the estate or to the property, because had he not acted, as we say he was obliged to, that could have created more problems from the authorities. So he was really in difficulty either way. But it's not clear at best that he's making any order for compensation prior to the 31st of May. My learned friend has referred to the various parts of the evidence in relation to the respondent's intention, that she was acting for the benefit of the estate. In relation to that, and in answer to that, we would invite the board to look at the evidence such as it is. Can I invite the board's attention to page 112 of the record? Top of the page, last 3 lines of the witness statement, her assertion that she informed the appellant she'd wanted the property for her children when he declined to accept rent from her. Can I give the board the further reference that goes to this issue? This is page 135 of the record, letter from the learned friend's attorneys.
So what's the page number?
Page 135. I'm taking this quickly because it's, but I will pause if the board wishes me to develop it. But it's page 135. And this really goes to the confusion as to what her status is. She says, I'm acting for the benefit, my learned friend's case is she's acting for the benefit of the estate. But if you look at page 135, third paragraph, she doesn't say for the estate. She says, our client wishes to exercise the rights of the statutory tenant by purchasing the property at 50% value. We've highlighted other references in our case. But if the character of the respondent in terms of her role is important, and my learned friend has drawn the board's attention to the case of Morgan and Thomas, could I invite the board's attention to the same page, 606 in the authorities, and it's the judgment at the bottom of the page of, I think it's Baron Pollock, and it's the second sentence, page 606. Unless the conduct of the party whose act is relied upon as binding the estate of the intestate be done by him in the character of administrator, it can have no operation upon the estate, and accordingly, the utmost effect that can be given to the defendant's argument is that where a party does an act professedly intending to take out letters of administration and afterwards becomes administrator, the administration has relation back and gives effect to what he had done by anticipation. What seems clear, and we've already taken the board to the other authorities on this issue, is that the motivation of the person acting is relevant to determine whether in fact she's acting for the benefit of the estate or for the estate.
It's different to say she's acting on, whether or not she's acting on behalf of the estate is a different question from whether she's acting for the benefit of the estate.
Well, we say she's acting for her own personal benefit, not for the benefit of the estate, and this is why we've drawn the board's attention to those parts of the evidence, because had the appellant accepted that she was the correct person with whom he should deal for the sale of the property, then she would have become the owner, not the estate, because it would have been transferred to her by conveyance. That is what she was asking for. And there is, we say, there's no other way to read those very clear statements in the correspondence, and when assessing what her intent was,
Mr. Parrow,
those were relevant.
I'm so sorry.
Sorry, my lady.
The first paragraph of the letter at 135 starts, we act on behalf of Angela Seeler, the legal personal representative, and then goes on to say who is in the process of applying for a grant of letters of administration. Yes. And what Chief Baron Pollock is saying is that the utmost effect that can be given to the defendant's argument is that where a party does an act professedly intending to take out letters of administration and afterwards become an administrator, the administration has relation back to give and gives effect to what he had done by anticipation. So the question I'm putting to you is, would the first paragraph there fall within what the Chief Baron was talking about?
Well, my lady, the answer we give is no, but it's the argument we make that when you look at the totality of the evidence that went to her motivation, went to her intent, you could not say, and she could not prove, which she needed to on the evidence for the doctrine to lock in place, that she was acting for the benefit of the estate. And we say that an objective assessment of the evidence, the evaluative assessment, if you like, demonstrates that what she was seeking to do was to obtain a personal gain. And we say that the Court of Appeal, in simply relying on one document, which the board can find at page, well, in fact, you can find it at page 131. When the Court of Appeal approached this issue, what was the intention of the respondent? They focused on what we have at page 131, which is simply the notice that says Angela Seeley, the intended legal personal representative. But what we have shown, and we've included it in our case, but I think it's generally accepted, is that during any evidential assessment to make a finding of fact like this, yes, you have to look at the contemporaneous documents, but you also look at the evidence given by the witness concerned in conjunction with the contemporaneous documents. That didn't happen here.
Yes, I see what you're saying. But I also just have to ask you about the fact that this is an objective assessment.
Yes.
So what she was thinking internally wouldn't matter. It's a question of what is objectively the position as to whether it was for the benefit of the estate.
Yes.
And it was open to the administrator duly appointed after grant of letters of administration to ratify.
Save that, in this case, on the evidence that was presented to the court, what we know is that she was moving, even before the trial took place, to secure the property directly. And we say that if the board accepts that that is what the evidence shows, then it did not enable the court to find, as they did below, that she was acting for the benefit of the estate.
What basis could she be claiming to act on some other than for the estate? How could she be claiming to be entitled to exercise the right to buy it at half price?
Milady, she shouldn't be able, in the capacity she, as a representative, be able to take the property personally. But that is exactly what she has said in various pieces of correspondence. And I made the point earlier, and I simply underscore it. If the appellant had accepted that, it would not have been a transaction with the estate. It would have been a transaction with the respondent directly. And if that's right, and we say it is because that's what the evidence shows, it casts serious doubt on whether she was acting for the benefit of the estate, and we do invite the board to consider it because the Court of Appeal did not. It's simply the evaluative assessment looking at the totality of the evidence, what she said in the trial, what she said in her witness statement, and what was recorded formally on her behalf. But that's as far as I can take it. I can draw the board's attention to the evidence, and if the board accepts that, then it would also accept that it couldn't be construed as her acting for the benefit of the estate. And that, of course, comes back to the argument on the doctrine, milady. If the doctrine is to apply, contrary to the authorities we have referred to, for the benefit of the estate, as opposed to protecting the estate from injury, those parts of the evidence would rather suggest that she was not. I move on now to the respondent's case that there was a concession made before the Court of Appeal that the doctrine could apply. I would invite the board's attention to the transcript, page 278. And it's line 43 to 44. After weathering the storm, the appellant's counsel then said, "My lord, reluctantly, I have to say it would seem as if it can apply." Well, seem as if it can apply is not the same as making an unequivocal concession that it did apply, and we maintain, for the reasons we've given, that it did not. We also maintain that the way in which this was introduced, again for the reasons we've given, was not appropriate, and the board and the Court of Appeal should not have allowed the doctrine to be raised absent a cross appeal. In relation to the skeleton arguments that the board has been taken to, attaching the skeleton argument from the High Court, that has to be looked at in the context of the notice of appeal, which had a single issue, challenge to the finding of the respondent being a tenant, and also the skeleton argument that they made does not, in fact, say that they are adopting the submissions in relation to relation back. What they actually said, and this is the this is in the record, page 251, paragraph 3. All the appellant did, or the appellant's counsel did, was to record in the skeleton argument what had happened in the court below. On the issue whether the respondent had the locus to sign the purported notice to renew, the court, in brackets rightly, rejected the respondent's contention that relation back applied. This would have resulted in the respondent not having the locus to sign the notice. And when one looks at any reference to the submissions that were attached, of course, in the submissions that were attached, they dealt with the issue of whether, in fact, she could be the tenant. And so when the board comes to look at those documents, this is at page 253 onward, the correct interpretation of what the appellant did in the Court of Appeal was to simply refer, in short, to the arguments they had made on the respondent being the tenant that they had made in the court below, because that was the only issue triggered by the notice of appeal. And so that I think the board probably has it, but just in case, it's The notice of appeal can be found at page 240, and it's paragraph 2B1. Which only challenged that the claimant, then now respondent, was a tenant. Interesting, my lady, there is an appeal coming to the board which is going to deal with that issue of the Court of Appeal not allowing submissions to be made, and I regret that I was the person not allowed to make the submissions, but that may be for next year. My lady, in relation to the other matters that have been raised, my Lord Stevens asked the question about limitation. I have a definitive answer, I think is what my Lord Stevens wanted, and the definitive answer is it is not in fact the limitation of certain actions act that my learned friend referred to. It is in fact the Real Property Limitation Act, and we will ensure that this is sent to the board. Malona Jr. has got everything ready on an email to go. The Real Property Limitation Act, Chapter 56(3), is the applicable piece of legislation. The Limitation of Certain Actions Act, just to draw the distinction, deals with law of tort, contract, things of that nature. Section 3 provides, no person shall make an entry or distress or bring an action to recover any land or rent, but within 16 years next after the time at which the right to make such entry or distress or to bring such action shall first accrue to some person through whom he claims, or if such right shall not have accrued to any person through whom he claims, then within 16 years next after the time at which the right to make such entry or distress or to bring such action shall first have accrued to the person making or bringing the same. What it comes to, pursuant to Section 3, is that if there has been a trespass, you've got 16 years. And if you take it from the end of the lease, 31st of May 2011, I think that's 2027. So there is time if, in fact, the action for trespass is good.
Well, let's take that on a bit further. There was a method sorted out at paragraph 35 of Mendel, I think.
Sorry.
Saving people a whole lot of costs. So what's your suggestion?
Sorry, my lord, I didn't get the reference you were...
Well, it's the... just give me one moment.
So, of course.
It's Milburn again. Milburn
Smell. Yes.
And paragraph 35. May I say, that's against the background that the landlord, the appellant, didn't inform the respondent as to who the relevant parties were. Yeah. They didn't even know before they started these proceedings that there had been an assignment of the freehold interest. And so all that was kept quiet. And it only became apparent when the defense was served. And all the three landlords should have been joined in this action. And they also should have been at risk in relation to costs in this action, all three of them. And so I was just wondering whether or not some practical solution, if in fact these proceedings are a nullity, some practical solution is being proposed on your side.
It's not something that I've taken any instructions on, but I hear what my lord said, and that may be a discussion to be had. But what we would indicate is that this point having been taken at the outset, it was actually taken on the preliminary application on the 27th of February 2012. It ought to have been accepted. It was put in the defence. It was raised again in the Court of Appeal. There's no reason in principle why the appellant, should the appeal succeed, not have his costs for these proceedings. And as the board may know, I think the Court of Appeal may no order as to costs, as I recall. But did all the costs?
You did sit back. You could have appealed the interlocutory order.
Yes, and as I say,
chose not to.
Well, I'm suddenly remembering the Court of Appeal. That is right. They could have, and they didn't. But this could have been addressed in the Court of Appeal, and it was raised in the Court of Appeal, and could at that stage have been allowed and sent back for a retrial or a fresh claim initiated. Now, it should not have been necessary, we say, to come before the board if that was the right approach. The Court of Appeal ought to have corrected it.
Just wondering what the best foot forward would be.
Well, I'll take it on board, but my Lord, I hope I've answered my Lord's question in relation to the main issue that you asked me about. My Lord, in relation to the question that was discussed in relation to the Administrator General, again, we will provide the extract. I think the relevant extract is section 17 of the Administration of Estates Act, chapter 9(1), and it does make provision that the Administrator General may, subject as is provided in the Wills and Probate Act, apply to the court for letters of administration, general or restricted as the case may be, to the estate and the effects of any person, whether domiciled in Trinidad and Tobago or not, who shall have died possessed of property, real or personal therein, intestate, or any person so dying having made a will, and the will for whatever reason does not become effective. So it did provide yet another option for the respondent, should she have wished to do so, to approach the Administrator General that this was a course of action that should be taken to renew the lease before the lease expired. Again, another option not taken in what was otherwise a very long delay. My lady, questions were put in relation to the rights of the landlord in relation to the tenancy that may exist. Can I deal with that now? The Land Tenants Security of Tenure Act does refer to the Land Commission, and it also refers to the Rent Assessment Board. Sudden frustration that many practitioners have encountered over the years. The difficulty was that the Land Commission was not created, and the Rent Restriction Act lapsed some time ago, and so there's no Rent Assessment Board. My understanding, subject to correction, is that you would have to approach the High Court to make any relevant application for this purpose. So it may be worth that the board is aware of that. But having said that, if the renewal has been validly made, it is the nuclear option to order possession in favour of the landlord, because it's a 30-year lease if it's been renewed. And I have not come across a case, and we did look at this particular issue, where because of a failure to pay rent, that the nuclear option was taken. Normally some other order has been agreed, but there's certainly nothing that we could find in the authorities that suggested that possession would necessarily be ordered in a lease of this kind. However, the board will note that that's generally because the house is still on it and there's a tenant in it. This house is gone. My Lord posed the question, I think my Lord Legate, in relation to pleadings, defence, and pleadings that may have been settled by a person other than the administrator, but then an administrator is appointed and might then say, well, I take a different view in relation to concessions and so forth.
That was Lord Stevens, actually. But...
Was it Lord Stevens? Forgive me, Lord Stevens. My apologies. Lord Stevens, I meant. The position in Trinidad and Tobago, and it has been the subject of some discussion before the board in other appeals, but the long and short of it is, it's very difficult to make changes to statement of case. The relevant rule is Rule 20.1, and in effect, the rule is drafted in negative terms, and the relevant part of it is subsection 3.
Well, I wasn't concerned about that.
Yeah.
I was concerned that if you had the principle of relation back, and you operated that principle
Yes.
rather than the rules of court, then the administrator, once appointed, could say, oh, no, I'm not going to stand over that.
Yes.
So it doesn't depend upon the rules of court. It depends upon the principle of relation back.
It does, but it also creates an even more intolerable situation where you cannot act with certainty on a person who says, well, I'm acting as if I'm the administrator, even though I've not got letters of administration, for exactly the reason that whoever does finally get them can take a different view. And that could scupper proceedings, which may already have been long delayed, but if that situation were to arise.
Run the proceedings right to the very end.
Yes.
And then when an order for cost is made, you could say, oh, well, I'm not interested.
Yes. And when you say very end, it could even be the very end to the board in some respects. And that is, and the lawfully appointed administrator would probably be on some significantly strong footing by saying, well, that person never had the authority, whereas I do. Close this.
I'm suggesting it, but there could be situations in where, for various reasons, different views are taken by different people.
Absolutely.
And they might operate in such a way that in tandem, so it didn't operate to the benefit of others.
I agree. So. My Lord, my Lady, the final arguments we would raise in reply relates to the doctrine as we've been discussing. If it applies for the benefit of the estate as opposed to injury or interference to renew a lease, in light of the delay in this case and likely delay in future cases, it will put the position of landlords for land tenants under this Act in a state of uncertainty. And this case before the board is a good example, because although we've discussed hypotheticals, and I know the board would wish to give a ruling that has potentially broader implications, we say that the application of the doctrine, as the cases show, should be fact-specific. We cannot, in this case, cater for the perhaps very broad range of cases that might arise where the doctrine could potentially apply or may not apply. What we know is that this case is about the Land Tenants Security of Tenure Act, a very specific piece of legislation which has deprived landlords of their rights and therefore should be strictly construed. And in this case, we know and we maintain and we urge the board to accept that the long delay here should have been explained if one is acting for the benefit of the estate, because surely, if that is the relevant criteria to trigger the doctrine, somebody acting for the benefit of the estate must act urgently, efficiently, before the lease expires, to say, well, look, there is a right to renew here, I've got to get my letters of administration, I know I should get my letters of administration, let me do it. And in this case, there was no reason why that could not have happened. And to make good the point that timing never had to be an issue in this case at all, could I invite the board to look at page 130? And if the board were to look at the first paragraph, there's a significant issue, we would say, that arises. The date of this letter is the 11th of January 2011, some months before the lease expired. And according to the last sentence of the first paragraph, the attorneys acting for the respondent said, we have received instructions from our client to apply for a grant of letters of administration of her late mother's estate on her behalf. Accepting that at face value for the moment, the question must arise, why was that not done? It could have been done. The letters could have been issued before. The tenancy could have been assigned, if to the respondent, and the notice to renew issued in the proper way by the tenant. These facts are relevant to the question of whether the respondent is acting for the benefit of the estate. Because if she's on notice, I've got to have letters of administration, I know I should before I can renew, she's given instructions to her attorneys to do that, then it may be her attorneys, on the face of this letter, who did not act expeditiously, but that her remedy would not lie as against the landlord. Her remedy would lie potentially against those who she caused the letter to be written. But as I say, it's dealing with this point that if benefit is enough, if it's benefit to the estate, then benefit to the estate must require a sense of urgency on the part of the person acting to benefit the estate, and in this case, she wouldn't satisfy that criteria. The expiry of the lease, I turn to that now. And again, even if benefit is enough, the doctrine still would not operate to revive a right that had already extinguished. And it would be problematic if it were otherwise, because I think the situation would be, if benefit can extend to the renewal of the lease in principle, we say that would be only problematic to the landlord in circumstances if the appointment of administration preceded the expiry of the lease. So if she'd, as I've referred to this letter, if she'd obtained her letters of administration at that time and issued the notice, then her actions are valid, because there's still a live 30-year lease running. But, and here the uncertainty, if the appointment of the administrator takes place after the 30-year lease has expired, which we say happened here, then even though the notice might have been served before the expiry, it would be wrong to apply the doctrine of relation back to reverse the expiry, in effect, resurrecting a new, or bringing into being a new lease. And we say it is wrong because to rule otherwise, the position of the appellant landlord becomes impossible, because all he can know for sure is that when the lease expires under the Act, he has a fixed date at which he should be able to re-enter the property, assuming no valid renewal has been made. If the doctrine operates so long after the expiry of the lease, it effectively brings life back to something which has already extinguished.
Well, the lease is extinguished, but the right exercised by the notice, if properly exercised, and that's obviously an issue, hasn't been extinguished. Therefore, the lease continues.
We have never argued, my lady, and I accept that if there has been a valid notice issued, then that must lead to another 30-year lease. We, of course, dispute that a valid notice was issued, but when you consider the situation here in applying the doctrine, you can have a position where the landlord does enter onto the property after the 31st of May 2011. He's not received a notice from anyone who's entitled, who is the administrator, or who is the new tenant, which is the requisite position. He entered the property in 2012. So by virtue of the appointment of the letters of administration, that which was lawful has become unlawful. He's gone onto the property.
Oh, see, well, it doesn't affect him.
Well,
It can't be a relation back. You can't really apply it to him. You apply it to what is done by or on behalf of the duly appointed administrator.
But it would then make, operating in that way, the period he has now gone into occupation,
unlawful. That's the inevitability of a relation back.
Then suddenly, that which he thought he could do, he's done wrong.
That's an inevitability of relation back or ratification.
Which we would say, my lady, on that very point is why the doctrine should be very restrictive, that it should not bring about that result which we say is absurd, that a landlord who acts lawfully, because there's been no valid renewal by a proper person, suddenly is put into jeopardy because letters of administration have been awarded a year later, 2 years, 3 years, whatever it may be. And if the limitation period is good, 16 years, does that mean that they've got 16 years after they've served the notice to get letters of administration? The landlord is in an impossible position.
If the rent is continued, if there is continuation of payment of rent, then are you prejudiced in a way of which the law should take note?
Yes, because the question arises, from who is the rent being
Well, you
paid?
can always find that out, and if it, you
Well-
don't have to accept it.
And he didn't in this instance.
Yes.
The reason being, the requisite administration was not something the respondent had at the time. And I've made the argument, I don't want to repeat it, that if you start accepting rent from someone who is not in fact the tenant,
Yes.
it can potentially create new rights, which was not intended by anybody, or certainly by the landlord. And so this is why we say that the doctrine should not operate in this case. So could I just pause for a moment to speak to my... Finally, this, my lady, the Land Tenant Security of Tenure Act, considered by the board in the two cases we've referred, was certainly generous in what it offered and gave tenants. If it operates strictly, as we say it should, it would be wrong to apply the doctrine in this case. And if the doctrine is applied, it does have implications for this type of case, where, as we have seen, the delay between a person dying and letters of administration being taken out can run into many, many years. In this case, I think the period was 6 years from the date of death to when letters of administration were applied for. So, my lady, those are my submissions, subject, of course, to any other questions the board may have in relation to any area that I either didn't deal with or the board would like me to deal with.
No, it appears not. Thank you very much indeed for your submission, Mr. O'Harrell. And may I just make it clear, if anyone on going back to look at Hark and Sing considers that there is some point they want to make, of course, they should let us have that in writing, but within 7 days, if I may say that.
I'm very grateful. Thank you.
And I did mention another case which nobody's had time to look at, which was Danish mercantile. If anyone wants to look, and Beaumont, if 1951 Chancery, if anyone wants to say anything about that, I think they should be able to do so within the same time frame, since I've referred to it in argument. That's a case where the liquidator ratified the bringing of proceedings by an unauthorised person, even though the court was satisfied the proceedings were, without that ratification, a nullity.
Perhaps also Hastrap.
Hastrap, yes, can you give the reference?
Yes, the Hastrap, and the reference is 2016 EWHC 12, open brackets, CH, close brackets.
Very well. Well, it's clear that the board will want to consider the submissions which have been very helpfully made and take time to consider its judgment and to bring it to your, to communicate it to you in the usual way. So we will now adjourn and take time to consider our judgment. But thank you everyone who's made submissions or contributed to the preparation of the case. Thank you very much, Mr. McQuilkin. We'll now rise. Thank you.